There's a clause I see show up in agreements of purchase and sale once in a while, and it's very much designed to protect the seller. Now, it sounds good, it's well drafted, and it doesn't work. And today I'm going to show you exactly why. My name is Zachary Soccio-Marandola. I'm a lawyer here in Toronto, and I help people like you close real estate deals every single day. Now, if you enjoy this type of content, make sure you subscribe and join our community. And if you have a closing coming up, we've built the most transparent legal fee calculator online. It gives you a full breakdown of every dollar you'll spend, and even calculates closing costs like land transfer tax and title insurance. That's linked in the description below. So before we talk about this clause, we're going to quickly talk about deposits. So when a buyer submits an offer, they put forward a sum of money, the deposit. That money gets held in trust, typically by the listing brokerage, while the deal works its way towards closing. Now, at a high level, here's what the common law says about that deposit when a deal falls apart. So if the buyer fails to close, if they walk away from the deal when they were legally obligated to complete it, the seller is generally entitled to keep that deposit. The seller doesn't have to prove their losses, and the deposit is forfeitable. And it works the other way too. If the seller is the one who defaults, if they fail to close when they were supposed to, the buyer is entitled to their deposit back. And depending on the circumstances, they may have additional remedies on top of that. So the deposit is not just a gesture of good faith, it has real legal consequences tied to who breaches the agreement. Now here's where it gets interesting. So I see a clause show up in agreement of purchase and sale every once in a while. And whoever drafted it clearly understands the problem they were trying to solve. It reads like this. Should the buyer fail to complete this agreement on the completion date at no fault of the seller, the deposit shall be deemed to be released by the buyer and paid to the seller by the deposit holder without deduction. This clause shall constitute the buyer's irrevocable consent to release such deposit, and no further written release shall be required. So what is this clause trying to do? It's trying to create a contractual mechanism that bypasses the normal release process. It deems the deposit released. It pre-authorizes the deposit holder to pay it out, and it says no further written release is needed. Now on paper, it looks like it solves the problem. If the buyer fails to close, the seller just gets the deposit back automatically, no fighting over it. Now the problem is the four words sitting right in the middle of that clause, at no fault of the seller. Here's why those four words break the whole thing down. In Ontario, a deposit holder, usually the brokerage holding that money in trust, can only release a deposit in specific defined circumstances. Those are if the deal closes, if both parties sign a mutual release, or a court order instructs the deposit holder to release it. That's it. Those are the only three ways a deposit moves. Now look at the clause again. It says that deposit releases if the buyer fails to close at no fault of the seller. But who determines fault? Who decides whether the seller is at fault or not? The buyer thinks it was the seller's fault. The seller thinks it was the buyer's fault. They both have lawyers. They both have positions. Neither party has the unilateral authority to make that determination. Fault is a legal conclusion. It requires either an agreement between the parties, which is a mutual release, or a judge to decide. So even with this clause in the agreement, even with the buyer's irrevocable pre-authorization sitting right there in the contract, the deposit holder still can't release that deposit based on the clause alone. Because the condition that triggers a release, no fault of the seller, cannot be established without the very process the clause was trying to avoid. Now, the clause assumes its own conclusion, and that's essentially why it doesn't work. So let's be clear about how a deposit actually gets released, because this matters in basically every transaction. 1, the deal closes. So the deposit gets credited towards the purchase price. This is the normal outcome we see most of the time. 2, both parties sign a mutual release. This would be the second most common. So if a deal falls apart, the buyer and seller can agree in writing on what happens to the deposit. In a lot of cases, it is returned. But again, it depends on the facts of the situation. Both sides have to agree, and both sides have to sign this agreement. And number 3, of course, is a court order. This is the least common, but if the parties cannot agree, either side can bring an application to court and let a judge decide based on the facts. This is the route that takes time, costs money, and creates uncertainty for everyone involved. So while it's a well-intentioned clause, it does not override the law. In Ontario, deposits are released on closing by mutual release or by court order, and this contractual language does not override it. If you're seeing this clause in agreements, now you know exactly why it doesn't hold up. If you're enjoying these behind-the-scenes real estate law videos, make sure you subscribe to the channel. I post a new video every week. And if you're a realtor, I also send a weekly update about different legal situations that come up in our closings. That's our realtor newsletter, and you can subscribe to it with the link down in the description. Thanks for watching.